Good morning, everyone, and welcome. My name is John Rogers, and I'm an environmental manager with the Division of Oil, Gas, and Mining, and I've been appointed by the Board of Oil, Gas, and Mining to act as a hearing examiner in this proceeding. Today is Wednesday, August 21st, 2024, and this is a time and place for the hearing examiner proceeding for docket number 2024-041, cause number 472-03, in a matter of request for agency action of Untitled USA Incorporated for an order pooling interest, including compulsory pooling of their interest of certain non-consenting owners in the Devereaux, Utah 1-14, 4-1-13-24-78 well in the drilling unit established for the production of oil, gas, and associated hydrocarbons from the Lower Green River West Formation comprised of all sections of 13 and 24, Township 4 South, Range 1 West, Uinta Special Meridian, Uinta County, Utah. We are holding this hearing with an anchor position in the Department of Natural Resource Building in Salt Lake City, Utah. We also will be hearing testimony and presentations in person and virtually, and the proceedings will be broadcast on the internet. I wish to thank the division staff, legal counsel, petitioners, and department technical staff for allowing these proceedings to go forth both remotely and in person. Before we begin, are there any members of the public or respondents present that wish to comment on these proceedings? Let the record show that no public respondents are present. We'll take appearance of counsel this time. Petitioner?
Fred McDonald of Lear & Lear on behalf of petitioner of Untitled USA Inc.
Division?
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
My counsel, Gary White of the Attorney General's office. I've received declarations from Mr. Peter Burns, a land advisor for Untitled USA Incorporated, and Mr. Christopher Wall, a reservoir engineer advisor for Untitled USA Incorporated, for the matter and have reviewed them before this hearing. Both individuals have testified before this board of witnesses. Is that correct?
That is correct.
Does the division have any objection to these declarations or individuals being qualified as expert witnesses?
No objection.
Okay, thank you. They are each recognized as experts in their particular field of study and work for this matter. Mr. McDonald, are the witnesses present today?
They are appearing virtually pursuant to the board's August 19th order.
And can we swear them in at this time? Would that
Yes.
be appropriate?
Mhm.
Okay.
Please raise your right hand. Do you solemnly swear that the testimony you shall give in this proceeding shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do. Yes.
They'll be accepted as expert witnesses for today's hearing. We'll now proceed to Mr. McDonald for his presentation.
Thank you, Mr. Rogers. And just to clarify for the record, Mr. Burns is being recognized as an expert in the area of petroleum land management, and Mr. Wall is being recognized as an expert in the area of petroleum engineering.
Okay, thank you.
Before we begin, I want to confirm that the division and the hearing examiner received the supplement to Exhibit 21 that was filed on Monday. Those are simply the updated certificate of mailings showing the status of those. Okay, you do receive that. Okay. The board, and by designation, the hearing examiner has jurisdiction over this matter pursuant to Utah Code Annotated Section 40-6-6.5. and the implementing regulations found at R 649-2-8A and R 649-2-9A. A copy of the request was mailed certified mail to the known parties sought to be compulsory pooled and mailed regular mail to all other production interest owners in the drilling unit at their last addresses disclosed by the relevant realty records and Ovintiv's internal records. It was also mailed to the Ute Indian Tribe, Ute Distribution Corporation, Bureau of Indian Affairs, Uinta Agency, and the Bernal Field Office of the Bureau of Land Management, who serves as a technical advisor to the Bureau of Indian Affairs, due to the tribal mineral ownership within the drilling unit. In addition, the notice of the filing of the request and the hearing was also duly published in the Uinta Basin Standard and Vernal Express on July 31st, 2024, in the Deseret News on August 2nd, 2024, and in the Salt Lake Tribune on August 4th, 2024. On August 12th, 2024, the division filed a response expressing no opposition to the granting of the request for agency action, and no other objections or responses to the request were timely filed. I'm going to provide a summary, and I'll refer to the exhibits on the PowerPoint. And again, if the hearing examiner of the division have any questions, about these exhibits. They can also ask the witnesses later on. This cause involves the compulsory pooling of the drilling unit established for the Lower Green River Wasatch production, comprised of the entirety of sections 13 and 24 of Township 4 South, Range 1 West in Duchesne County. The drilling unit was established by the board's order entered in cause number 60002, which was submitted as part of Exhibit 2 in this matter. As reflected by Exhibit 8, which is shown on the PowerPoint, Ovintiv is the majority working interest owner in this drilling unit. And it's also referred to in paragraph 12 of Mr. Burns's declaration. The 60002 order was modified the previous board order entered in cause number 266-03, which established 40-acre drilling units in the south half of section 13. Prior to entry of the 6002 order, the north half of section 13 and all of section 24 were not spaced, and therefore subject only to the general well siting rule and the rule of capture dealing with production allocation.
Can I ask you a question?
Sure.
You said 24 was rule of capture.
Correct.
And 13 was only spaced half of it?
Yes, the south
The
half
south half.
previously.
Okay.
Okay. Then pursuant to the 26603 order and the general well siting rule, Newfield, as Ovintiv's predecessor by merger and name change, drilled the wells outlined in paragraph 2 of the request for agency action and as designated on Exhibit 7, which I've shown on the PowerPoint. The 60002 order expressly vacated that order, that 26603 order, and production from these existing wells would then convert to the section 13 and 24 drilling unit basis on the first of the month following the date of first production of the first long lateral horizontal well, which is in excess of 1 mile in length, drilled on the drilling unit. Therefore, in accordance with the 60002 order, as modified by the board's order in cause number 60003, which simply reduced the heel-toe setbacks, Ovintiv drilled the Devereaux well at issue with first production on August 3rd, 2021, as outlined in paragraph 10 of Mr. Burns's declaration. The conversion date then for these existing wells occurred effective September 1st, 2021. Subsequent to the 60002 and 60003 orders, the board then entered in cause number 60005, pursuant to which the 60002 and 60003 orders were modified to expand the drilling unit to include section 25 of the captioned township, which was a partial township or a partial section due to the UNS Special Meridian, but only upon the drilling and production of an additional long lateral horizontal well in excess of 10,000 feet in length, penetrating said section 25. A true and correct copy of the 605 order was submitted as the remainder of Exhibit 2. As outlined in paragraph 7 of Mr. Burns's declaration, no long lateral horizontal well in excess of 10,000 feet and penetrating section 25 has yet been drilled. As a consequence, the drilling unit currently remains just section 13 and 24. There are 4 specific parties to be compulsory pooled and declared as non-consenting parties in the Devereaux well: Donald W. Sanders Jr., Linda Lou Sanders Howard, Allison Michelle Shimmer Black, and Ian M. Shimmer. As reflected in exhibits 9 through 15, which I did not have a PowerPoint for, and paragraphs 14 through 18 of Mr. Burns' declaration, the requisite notices of opportunity to participate in the Devereaux well were provided to these 4 parties, but none timely responded. Their collective gross working interest in the drilling unit, as shown on Exhibit 8, is 0.208529%. In addition, although Ovintiv believes it has leased all such successors and voluntarily pooled their interest pursuant to the pooling clauses contained in their leases, there may be additional parties claiming buy-through under certain decedents, as identified in paragraph 19 of Mr. Burns' declaration, whose estates have not been probated in Utah or are incomplete in distribution of the subject mineral interest. Pursuant to the board's order entered on July 15, 2024, the requisite notices of opportunity to participate were provided to them by publication. As Mr. Burns' declaration states, no responses were timely received to that publication. Replacement Exhibit 16 in this cause is a true and correct copy of the affidavit of publication of the notices of opportunity to participate received from the Vernal Express. As reflected on Exhibit 17, which is a two-page exhibit, which I'm showing on the PowerPoint and pointing to the last page. And also in paragraph 24 of Mr. Burns's declaration, the average weighted fee landowner's royalty as of the date of spud of the Devereaux well is 14.488883%. As outlined in paragraph 25 of Mr. Burns' declaration, the parties shown on the certificate of service filed in this cause are all of the production interest owners in the subject drilling unit. Their names and addresses were derived from a 2023 title opinion as supplemented by a record search by Oventive's contract landmen at Lone Wolf Energy, Inc. and based on Oventive's internal records. Exhibit 21 as supplemented reflects the status of the certified mailings of the request to the four expressly named compulsory pooled parties. As the record will reflect, none of the parties identified in the request as being compulsory pooled and declared as non-consenting owners in this cause timely filed a response or have made an appearance today. Consequently, pursuant to Utah Administrative Code R 641-104-150 and R 641-108-400, Oventive moves to enter an order of default against them, and I would ask the hearing examiner to rule on that.
Yes, I agree with that.
Okay, thank you. As outlined in paragraph 6 of Mr. Wall's declaration, the estimated plugging and abandonment cost for the Devereaux well is $75,000. Exhibits 19 and 20 and paragraphs, there's 19 and 20. In paragraph 7 and 8 of Mr. Wall's declaration outline the risks assumed at the time of spud of the Devereaux well.
If you go back to the previous,
Yes,
so we're looking at the location of the horizontal well, the green, correct?
correct. Yes, the surface location is in section 14, and then the productive intervals are within
And
section 13.
Looking from here is, and are the dots in there in the southern half, the vertical wells,
Yes, and there's one short lateral or directional well in there.
and that's in 24. Okay, and I got that.
Okay. Again, Mr. Rogers, if you or the division need to see any of the exhibits, they're available on the PowerPoint, at least the visual ones. With that, I'll commence my examination. Mr. Burns. Mr. Burns, would you please state your business address for the record?
Yes, Peter Burns, and Oventive's address is 4 Waterway Square Place, Suite 100 in the Woodlands, Texas, 77380.
All right, and what is your current position with Oventive and how does it relate to this drilling unit?
I'm a land advisor for the Rockies Uinta team with responsibility over this drilling unit, among others.
All right, for the record, would you please state the corporate and bonding status of Oventive?
Sure. Oventive is a Delaware corporation in good standing with its principal place of business for Rockies operations in the Woodlands, Texas. It is duly authorized to conduct business in Utah and is fully bonded with all appropriate federal and state agencies. It is the successor by name change to Newfield Production Company and by merger of Oventive Production, Inc.
All right, Mr. Burns, I'm going to refer you to exhibits 3 through 15 and 17. 3 is on the screen. This simply shows the relationship, a regional locator map showing where the drilling unit is in relation to Highway 40 and the Mighton Townsite and Roosevelt. Exhibit 4, which simply shows the fact that these are not regular government sections and are comprised of lots and quarter sections. 5 shows the general well location of the Devereaux well within the drilling unit and shows whether it's fee simple or Ute tribal minerals. There's no state lands in this drilling unit, is that correct?
Yes, that's my understanding.
Okay. Exhibit 6 simply shows the different mineral ownership tracts within the drilling unit. Exhibit 7 was the exhibit showing the existing wells that were drilled prior to the Devereaux well. Exhibit 8 shows the working ownership within the drilling unit. The remaining exhibits are not on PowerPoint, except for exhibit 17, which was the average weighted landowner royalty. Were all these exhibits prepared by you or Oventive personnel or contractors with your review and input?
Yes, they were.
Okay, Mr. Burns, did you read through your declaration, and can you confirm for the record that all the statements made in that declaration are true or correct? Or if any modifications are required, would you please state them on the record?
Yes, I have read through it and I can confirm all those statements, and I am not aware of any modifications today.
Right, and since you've been qualified as an expert in petroleum land management, are the terms and conditions of the joint operating agreement that were submitted as Exhibit 15, are they fair and reasonable and consistent with those commonly accepted by industry, and in particular in the Uinta Basin with respect to horizontal well operations?
Yes, they are.
Mr. Hearing Examiner, I'll open up Mr. Burns for questioning by you or the division.
Division, any questions for this witness?
Yeah, Mr. Burns, I do have a question. As it was indicated, these lands are also subject to a new order of 600-05, where it incorporates the section just to the south.
My bad.
So, is he still there?
Yeah, he's here. Hit something that is not ready to go. I'm gonna have to find him.
Peter, can you still hear us?
Yes, I can hear you.
Okay, I'll just keep talking.
Okay, I'll find him. We'll get him back.
He's hiding somewhere.
He's in an incognito
We
window.
just lost your view, that's all. But it's
Well,
fine. So I was just curious, at some point in time, when Inventive drills a 10,000 foot or greater well, what is the intent there? Is it to come back and repool, and then this well will then be spaced on the new unit? Is that how we see this going?
Yes, I mean, when we come back to drill future infill wells in this DSU, we would also drill into section 25 and include that within the gross, acreage total of the 3-section DSU, so to speak.
Okay. And this isn't being done now because that order isn't in effect because you haven't met that drilling obligation under that order yet.
Right. That won't take effect until we drill a new well that is extended into section 25.
All right, thank you for clarifying that. And then I do have another question. It was mentioned that the address is used based on a title opinion from April 13th, 2023 to mail out to the non-consenting owners. Would that be?
Yes, you mean that? Oh, go ahead.
So my question is, just for the division's understanding, are your mailings based solely on the title opinion provided, or do you or a contractor make any other attempts to verify addresses of non-consenting parties?
Yeah, so that's kind of a baseline, that title opinion from April of 23, and then we carry it forward to, current day. And then also when we have these unclaimed or, unlocatable type addresses, we, Google search, white pages search, additional search of the county records, ancestry, if we're able to get a hold with other family members, trying to get her a better address that way. This is a thorough search. It's not just solely reliant on that title opinion.
Okay, thank you. That's all I needed. That's all I have from the division.
Thank you.
If I could make a point too, if the exhibits in this and the 4 people that we're talking about, they actually did receive the notices of to participate. So the addresses that were sent, they were sent to for the notice of opportunity to participate, as reflected in the exhibits, shows receipt.
Oh, okay.
In these 4.
Okay, I thought Linda Lou Sanders Howard and Allison Michelle Shino Black, I thought they did not.
No, I'm sorry, maybe I'm getting mixed up. Let me double check it.
And I could be too.
Well, there's so many of these and I apologize.
Do you know Peter?
Yes, I saw that Allison Shimmer Black, she just flat out refused the mailing.
Okay,
And
she refused.
Linda Howard, that was unclaimed. 2 separate attempts, one USPS and another by UPS. Both went unclaimed.
All right.
That's right. My apologies on that.
Oh, no, you're
But
fine.
this wasn't a publication situation.
Sure. Yeah, that's what I have from the division.
Okay, thank you, Adam. A couple of questions. If we look at the royalty there, I notice as I go through these, we see that range quite a bit. I think I understand why, but could you explain why that the royalty goes up and down so much?
Sure. So obviously the state or the tribal component is not included in the calculation, but because there are so many existing wells within this DSU, there is a lot of older HBP leasehold that factored into the calculation, and a lot of those leases were taken at an eighth, which just brings down the average when you calculate all the leases together.
This was a timing thing, age.
Right.
Yeah.
Their HB leases would have a
That's
less
what I
royalty
assumed.
than the more current ones.
And the tribal, why is the tribal significantly higher?
They have leverage to be able to do that, or Peter, if you want to go ahead and testify about that.
Yeah, I mean, oftentimes that is the result of a bidding process potentially. In the case of the tribe here, this is part of a much larger, it was part of an exploration and development agreement, or EDA, that covered, multiple townships. And I think just by state statute, the any tribal, federal, allotted state royalties are all excluded from the calculation.
I don't understand that completely. Also, this is interesting in that we're looking at, in section 13, a pooling order from 2010, correct?
Correct.
Now, what happens to that pooling order?
The 602 order, if you reviewed, vacated that order.
So then, when you say you're going to, if you owe them or you're keeping track of their, penalty, so to speak, at that time you just make them whole and you cancel it, or?
Well, again, under the 602 order, what happens is once they drilled that first log, this Devereaux well, any remaining recoupment that was owed under those pooling orders was waived, and it's on a forward basis. That was the agreement for the conversion aspect.
So when you mean waive, they no longer owe that to them?
That's correct. Peter, would you go ahead and address that?
Yeah, so under those subsequent orders, if they were still in a recoupment period, and we drilled the new well, it was just determined that we waived any remaining recoupment, and they were back into each of those wells as an 8/8 working interest owner.
Okay, so they become a working interest owner.
That's correct.
So it's kind of a win for them.
It is if there was something owed, but that was the trade-off to allow the conversion to the 1280. That goes back into that hearing of the 602 order.
Okay, so then as we move forward and you're doing this pooling today, if those same mineral owners are there, do they come in again and have the same option to come in and come into this new pooling order?
Legally, yes, correct. And some of those, I think some of those owners, and Peter, you can testify to this, I believe some of them have leased it since that time. Is that correct?
Yes, we've been able to lease some of those people who were previously like in the recoupment phase, but then these are the remaining 4 that we were not able to lease, who are going to be in a payout position in this horizontal well.
So the slate's kind of wiped clean. They either gotta join or, be pulled, but they don't get any benefit being in the old pooling order. It's just done away with.
Right, correct.
Okay. And then explain to me, and I should know this, the conversion process.
Peter, do you want to address that?
Sure. So any of these vertical wells, a lot of them were drilled just on a 40 acre or potentially 160 acre in the case of a tribal well, basis. And so part of the agreement in the conversion spacing is that when we came back in to drill anything over greater than a mile in length, so in this case, this Devereaux 7H well, all of those existing spacings were sort of wiped out and they converted to the 1280 spacing. So all of those smaller spacing units all converted to this larger, 1,280 acre space unit.
And that's based on the minerals they owned in section 13. Or, I mean, they go from only a little bit of a vertical well to a little bit of a bigger unit.
Correct, and if I can explain that, part of the reason and the concern is any frac hits.
Yeah.
If you kept them on separate drilling unit basis and there was a frac hit, it would create havoc on how you would allocate production amongst all of them. So that's why Ovintiv originally, or Newfield at the time, originally sought the conversion aspect, because now with conversion, if there's any communication between the wells, there's no harm, no foul, because everybody's sharing on the same basis on all the wells.
And I remember doing this years ago when it was Newfield and the conversion came at that time.
Right.
To effect.
Exactly.
I have no more questions for Mr. Burns. So would you like to continue, Mr. McConnell?
Yes, thank you, Mr. Rogers. With that, I'll commence my examination of Mr. Wall. Mr. Wall,
Yes, sir.
would you please state your name and business address for the record?
Name is Christopher Wall. Business address 4 Waterway Square Place, Suite 100, The Woodlands, Texas 77380. And I'm a reservoir engineering advisor with knowledge of this issue as well as others in the Uinta Basin.
Right, and again, Mr. Wall's been recognized as an expert as petroleum engineering in this matter. Mr. Wall, I'm going to direct your attention to exhibits 18, and I apologize for the way that this is showing up. It just, for some reason, that exhibit 3 in the middle is just got in there. Exhibit 19 and exhibit 20. Were these exhibits prepared by you or Ovintiv personnel with your review and input?
Yes.
All right. And I want to confirm for the record, have you read and can you confirm all the statements made in your declaration are true and correct? Or if you require any modifications to that, would you please state it on the record?
Yes, I have read my declarations and don't have any modifications at this time.
All right. Again, with your expert opinion as a petroleum engineer, are the actual costs that were shown on exhibit 18 for the Devereaux well fair, reasonably, and necessarily incurred?
Yes.
Was the Devereaux well deemed economically feasible to drill, as that term is utilized in the 600-02 order?
Yes.
And finally, are the risks that are reflected by exhibits 19 and 20 and as outlined in your declaration, do they justify the imposition of a 300% risk assessment award and is fair and reasonable under the circumstances?
Yes.
All right, Mr. Rogers in the division, I'll open up Mr. Wall for any questions that you may have on these, on his testimony and his declaration.
Division?
Yeah, can we go back to exhibit 18,
Yes.
please? So this well was drilled in 2021. Total costs in 2021, around 7.5 million. What, could you just explain, just for our understanding, as we see these all the time, as we go through 2022, 23, 24, the additional drilling costs, additional production costs, like what are those? What are those involved after the initial well has been drilled?
Specifically to this well, I'm not exactly sure. A lot of times though, we have corrective billing through the accounting process. So while these charges may have actually happened in 2021, they don't get booked until later years.
Okay.
Yeah, I mean, I assume there's production facility upgrades, production equipment upgrades, facility upgrades. We're just curious about drilling and completions, but yeah, I guess if it's bleeding over from the original drilling, yeah, just kind of surprised to see him out 3 years later, but.
Yeah.
Just for the record, that's Peter Penke
Oh, sorry.
with the division.
Thanks, Brad.
And then secondly, in your declaration, and I believe in the exhibit, you talk about operational challenges. On this well, you specifically cite increasing completion time due to equipment problems. Could you elaborate at all? We need both.
Yes, sure. So in this particular well, I don't recall how many pumps it was, but there are a number of pumps, pump trucks basically, that were failing, not allowing us to get to the required rate that we needed to complete the well. And so we were having to shut down, repair the pumps, and then pick back up and start pumping again on the completion.
All right, thank you. No further questions from the division.
Okay. I'm gonna date myself here, but going back to when we first started doing horizontal wells and the predecessor to this company, go back to the previous slide, please. Well, what's the cost? Or maybe it's the previous one of that. There we go. I remember wells being in the 12 to $15 million range for costs. What has caused that to come down so dramatically? Which is a good thing, obviously. But where are we seeing that savings?
Yeah, so I think today, this same well would probably cost closer to 9 million. So we've had a lot of cost creep, mostly due to inflation on tubulars. And then also maybe some design changes on the completions. So one of the big costs that we have is where we source our water for our completions. That can swing wildly, especially as you move away from our primary water source. So the farther you go, the more it costs to actually port the water there. The drilling stays relatively constant in today's dollars where you move across the field. And then facility side, we've had a lot of different design changes trying to improve our capture of methane and other, CO2, et cetera, trying to limit some of those emissions. So our facility has gotten quite a bit more expensive over time as well. Does that help answer your question?
I just remember them to be so much more expensive. Now you're looking at a well than what the $7.5 million range.
Is it the equipment and technology, Chris, that is improved that helped reduce the cost from, say, something that would have been drilled in the late 90s or early 2000s?
10 years ago.
Yeah.
Yeah, so I think there's several factors. I mean, yeah, we've definitely gotten more efficient as an industry in drilling in the basin. And I said, more specifically to today, we're trying to use a larger pad so we can stick more wells in one area, and that helps efficiently drill. But I mean, also on the completion side, infrastructure is another area where we can, larger pad sizes can reduce our infrastructure. So there's some efficiency stuff that's happening as we're not having to drill single wells. That's really driving costs down. And then, there's technology. We're definitely drilling wells faster than we used to. So I think maybe a combination of those things.
Okay, that's good to see. All right, thank you. I have no more questions for this witness. Do you, for this presentation?
And the division, we reviewed this request, we reviewed the exhibits and associated filings with this request, and based on the declarations and the comments and testimony given here today, the division is in support of this request.
Thanks, Andy. Well, this time I turn over some closing statements. First from
Thank you, Mr. Rogers. For logistical reasons, I'd like to get the exhibits admitted into evidence.
Sure.
Move for admission of exhibits 1 through 15, replacement exhibit 16, exhibits 17 through 20, and exhibit 21 as supplemented, as well as Mr. Burns and Mr. Wall's declarations.
Accepted.
Thank you. With that, we believe that the statutory and regulatory requirements have been satisfied, that the request is fair, reasonable, and justified, and we ask that the request be approved as submitted. Finally, I'd like to thank you for your time and also the DNR staff for making the virtual appearance available to the witnesses.
Division, you stated earlier, do you have anything to add?
Nothing additional.
Okay. I'd like to take a few minutes to deliberate with my counsel, and we'll go off the record at this time. I'll be right back.
Thank you.
Okay, thank you. One thing my counsel corrected me on, I did not ask you as a division whether you accept those exhibits as so stated by Mr. McDonald.
Yeah, we have no.
Okay, thank you. Um, Having reviewed the request for agency action and all exhibits, having considered the evidence presented here today, I find that Ovinius has provided sufficient notice of opportunity to the non-consenting CP owners and those owners identified in the request for agency action did not timely elect to participate in the wells and therefore should be deemed non-consenting parties. I find that a 300% non-consent penalty is fair and justified given the economic and geologic conditions present with these wells, and find that it would be appropriate to impose that requested non-consent penalty. I find that Ovintiv has met its burden of proof to show that they are entitled to forced pulling of the named interest and other relief requested in a request for agency action. Mr. McDonald, will you please prepare an order?
Certainly.
Okay. I then will present the findings and conclusions to the board next week at the board hearing. Any other comments before we close?
No.
Okay, if there are no more, we will thank you for your participation and we'll adjourn this proceeding at this time. Thank you. Good morning, everyone, and welcome. My name is Sean Rogers. I'm an environmental manager at the Division of Oil, Gas, and Mining, and I've been asked by the Board of Oil, Gas, and Mining to act as a hearing examiner in this proceeding. Today is Wednesday, August 21st, 2024, and this is the time and place for the hearing examiner proceeding for docket number 2024-042, cause number 132-47. In a matter of request for agency action of Ovintiv USA Incorporated for an interest order pooling interest, including the compulsory pooling of the interests of certain non-consenting owners in the Lamb, Utah 1-16, 4-1-9-4-1H well in the drilling unit established for the production of oil, gas, and associated hydrocarbons from the Lower Green River Wasatch Formation, comprised of all sections 4 and 9, Township 4 South, Range 1 West, Uinta Special Meridian, Duchesne County, Utah. We are holding this hearing with an anchor position in the Department of Natural Resource Building in Salt Lake City, Utah. We also will be hearing testimonies and presentations in person and virtually, and the proceedings will be broadcast on the internet. I wish to thank this division staff, legal counsel, and petitioners in the department, technical staff for allowing these proceedings to go forth both remotely and in person. Before we begin, there are any members of the public or respondents present that wish to comment on these proceedings. Let the record show no public respondents or present or, okay. We will take appearance of counsel at this time. Petitioner?
Thank you, Mr. Rogers. Fred McDonald of Lear and Lear, of counsel with Lear and Lear on behalf of petitioner Ovintiv USA Inc.
Division?
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
My counsel, Gary White of the Attorney General's Office. I have received declarations from Mr. Peter Burns, a land advisor for Ovintiv USA Inc., and Mr. Christopher Wall, a reservoir engineer advisor for Ovintiv USA Inc. for this matter, and have reviewed them before this hearing. Both individuals have testified before the board as expert witnesses. Does the division have any objection to these declarations, or are these individuals being qualified as expert witnesses?
No objections by the division.
Okay, thank you. They are each recognized as experts in their particular field of study and work for this matter. Mr. McDonald, are the witnesses present today?
They are, Mr. Rogers. They're appearing virtually pursuant to the board's August 15th order and are available to be sworn in at this time for their testimony.
Okay, can we swear them in at this time?
Please raise your right hand. Do you solemnly swear that the testimony you shall give in this proceeding shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Yes.
Okay, thank you. We will now proceed to Mr. McDonald for his presentation.
Thank you, Mr. Rogers. Again, just for the record, Mr. Burns has been recognized as an expert in the field of petroleum land management, and Mr. Wall has been recognized as an expert in the field of petroleum engineering for purposes of this class. I also want to confirm that Mr. Rogers and the division received the supplement to Exhibit 25, which again was the certified mailing receipts to the compulsory pool parties. Thank you. The board, and by designation, the hearing examiner, have jurisdiction over this matter pursuant to Utah Code Annotated Section 40-6-6.5 and implementing regulations found in R 649-2-8A and R 649-2-9A. A copy of the request for agency action was mailed certified mail to the known parties sought to be compulsory pooled and mailed regular mail to all other production interest owners within the drilling unit at their last addresses disclosed by the relevant realty records and Ovintiv's internal records, and to the Ute Indian Tribe, Ute Distribution Corporation, Bureau of Indian Affairs, Uinta and Ouray Agency, and Vernal Field Office of the Bureau of Land Management, who serves as a technical advisor to the Bureau of Indian Affairs, all due to the tribal mineral ownership within the drilling unit. In addition, notice of the filing of the request for agency action in this hearing was also duly published in the Uinta Basin Standard on July 31st, 2024, the Deseret News on August 2nd, 2024, and the Salt Lake Tribune on August 4th, 2024. On August 12th, 2024, the division filed a response expressing no opposition to the granting of the request for agency action and no other objections or responses to the request were timely filed. Again, Mr. Rogers, I'll have the exhibits available for you from PowerPoint if you have any questions or the division has any questions, and I'll go through them through my opening statement as well as the witnesses as they need to.
Okay, thank you.
This cause involves the compulsory pooling of the drilling unit established for Lower Green River Wasatch production, comprised of the entirety of sections 4 and 9 of Township 4 South, Range 1 West, UNS Special Meridian in Duchesne County. The drilling unit was established by the board's order entered in cause number 139-150. As reflected on Exhibit 7 and in paragraph 10 of Mr. Burns's declaration, Ovintiv is the majority working interest owner in this drilling unit. A true and correct copy of the 139-150 order was submitted as Exhibit 2 in this cause. In accordance with the 139-150 order, as modified by the board's order in cause number 603, which simply reduced the heel-toe setbacks, Ovintiv drilled the Lamb well at issue with first production on May 27, 2021, as outlined in paragraph 9 of Mr. Burns' declaration. In this matter, there are 9 specific parties to be compulsory pooled and declared as non-consenting parties in the Lamb well. Elizabeth Clemens, Scott Clemens, Jody Augustine Evans, Douglas John Clemens, Jennifer Schaefer, Becky Campbell, Ken Henry, Scott Henry, and Lori L. Charlton. As reflected in exhibits 10 through 12, 14, 15, and 17 through 19, and paragraphs 14 through 16, 18, 19, and 21 of Mr. Burns' declaration, the requisite notices of opportunity to participate in the Lamb well were provided to and received by 5 of these parties. As reflected in exhibits 8, 9, 13, 16 through 19, and replacement exhibit 20, and paragraphs 12, 13, 17, 20, 21, and 23 of Mr. Burns' declaration, the remaining 4 parties failed to pick up the transmitted notices after attempted delivery, and consequently, pursuant to the board's order entered on July 15, 2024, they were additionally provided the requisite notices of opportunity to participate by publication. None of the 9 parties ever timely responded. As reflected in Exhibit 7, their gross working interest in the drilling unit aggregately is 0.076577%. In addition, although Ovintiv believes it has leased all such successors except as to those parties and voluntarily pooled their interest pursuant to the pooling clauses contained in said leases, there may be additional parties claiming by, through, or under estates or certain decedents as identified in paragraph 22 of Mr. Burns' declaration, whose estates have not been probated in Utah or are incomplete in distribution of the subject mineral interests. Also pursuant to the board's order entered on July 15, 2024, the requisite notices of opportunity to participate were provided to these unknowns by publication. Again, no timely responses were received. Replacement exhibit number 20 in this cause is a true and correct copy of the affidavit of publication of the notices of opportunity to participate received from the Uinta Basin Standard. As reflected on exhibit 21 and paragraph 27 of Mr. Burns' declaration, the average weighted fee landowner's royalty in this cause is 15.273043%. As outlined in paragraph 28 of Mr. Burns' declaration, the parties shown on the certificate of service filed in this cause are all of the production interest owners in the drilling unit. Their names and addresses were derived from a 2023 title opinion as supplemented by a record search by Ovintiv's contract landmen at Lone Wolf Energy, Inc. and Ovintiv's internal records. Exhibit 25 is supplemented, reflects the status of the certified mailings of the request to the 9 expressly named compulsory pooled parties. As the record will reflect, none of the parties identified in the request as being compulsory pooled and declared as non-consenting owners in this cause timely filed a response or have made an appearance today. Consequently, pursuant to Utah Administrative Code R 641-104-150 and R 641-108-400, Ovintiv moves to enter an order of default against them, and I would ask the hearing examiner to rule on that.
Yes, we'll accept that.
Thank you. As outlined in paragraph 6 of Mr. Wall's declaration, the estimated plugging and abandonment cost for the Lamb well is $75,000. As reflected on exhibits 23 and 24, and paragraph 7 and 8 of Mr. Wall's declaration. These outline the risks that were assumed at the time of the spud of the Lamb well. With that, I'll commence my examination of Mr. Burns. Mr. Burns, again, would you state your name and business address for the record?
Yes, Peter Burns, and Oventive's address is 4 Waterway Square Place, Suite 100 in the Woodlands, Texas, 77380.
And what is your current position with Oventive and how does it relate to the drilling unit at issue?
I'm a land advisor for the Rockies Uinta team and have responsibility over this drilling unit, among others.
All right, would you state for the record the corporate and bonding status of Oventive?
Sure. Oventive is a Delaware corporation in good standing with its principal place of business for Rockies operations in the Woodlands, Texas. It is duly authorized to conduct business in Utah and is fully bonded with all appropriate federal and state agencies. It is the successor by name change to New Fuel Production Company and by merger of Oventive Production, Inc.
Mr. Burns, I'm going to direct your attention now to exhibits 3 through 19 and 21. Starting with exhibit 3, which I'll show on the PowerPoint. This is a regional locator map showing the drilling unit in its relation to the Mighton town site in the city of Roosevelt. Exhibit 4 shows the lots that comprise section 4 to show that it's an irregular section. Exhibit 5 shows the general location of the Lamb well within this drilling unit and also outlines the general mineral ownership, whether it's fee simple, state, or Ute tribal. Although, could you confirm that for the record, there's no state minerals in this drilling unit?
Yes, I don't believe there are any.
Okay. Exhibit 6, which shows the various mineral ownership tracts within the drilling unit. And then exhibit 7, which shows the working interest in the drilling unit. And then the exhibits 8 through 20 are not shown. And then exhibit 21, which shows the average weighted royalty calculation. Were they all prepared by you or Oventive personnel or your contractors with your review and input?
Yes, they were.
All right, would you confirm for the records that you have read, and can you confirm all the statements in your declaration are true and correct? Or if any modifications are required, would you please state them on the record?
Yes, I can confirm that all the statements made in the declaration are true and correct, and I don't have any modifications at this time.
All right, again, you've been recognized as an expert in petroleum land management. Is it your expert opinion then that the terms and conditions of the joint operating agreement submitted as Exhibit 19 are fair and reasonable and consistent with those commonly accepted by industry, and in particular the Uinta Basin with respect to horizontal well operations?
Yes, I believe so.
Mr. Rogers, I'll open up Mr. Burns for questioning by you in the division.
Okay, division?
Division has no questions, Mr. Burns.
Okay, I don't have any either at this time for Mr. Burns, so we can move on.
Thank you, Mr. Rogers. With that, I'll commence my examination of Mr. Wall. Mr. Wall, would you please state your name and business address for the record?
It's Christopher Wall, 4 Waterway Square Place Drive, Suite 100, The Woodlands, Texas, 77380.
And what's your current position with Oventive and also its relationship to this drilling unit at issue?
I am a reservoir engineering advisor for Oventive and have jurisdiction over this DSU as well as others in the Uinta Basin.
Thank you. I'm going to show you what have been marked as exhibits 22, 23, and 24 for purposes of this cause. Were they prepared by you or Oventive personnel with your review and input?
Yes.
All right. Could you confirm for the record that you have read and can confirm that the statements made in your declaration are true and correct, or if any further modifications are required, would you so state them for the record?
Yes, I have read and my declarations. I don't have any changes at this time or modifications.
Thank you. Again, you've been recognized as an expert in petroleum engineering for purposes of this cause. Is it your expert opinion that the actual cost of the Lamb wells at issue reflected in Exhibit 22 were fair, reasonably, and necessarily incurred?
Yes.
Is it also your expert opinion that the Lamb well was economically feasible to drill, as that term is utilized in the 139-150 order?
Yes.
Finally, the risks that are reflected on Exhibits 23 and 24 Do they justify the imposition of a 300% risk assessment board and are fair and reasonable under the circumstances?
Yes.
Mr. Rogers, that concludes my examination. Mr. Wall, and I'll open them up to questions by the division and yourself.
Division?
Yeah, Mr. Wall, similar question to before, indicated that operational challenges, in this case were, drilling time due to stuck assembly, motor failure, worn bit, increased completion time due to high pressure leak. Just for our understanding, could you explain, what was involved in the high pressure leak? If you were involved in the drilling in 2021.
Yes, looking through the records on the completion for the high pressure leak seemed to be a wellhead to, man, I'm blanking on the term, but anyways, the tubing or the piping that goes from the wellhead to the pressure pumping equipment, there was a leak at that union, and it did take a couple of days to repair.
So once this leak was found or happened, you shut down all operations for a couple of days for repairs?
Yeah, so we always test our equipment, pressure test our equipment after every single time we have to reconnect. And so every time we are making a gun run or something like that, we will go ahead and pressure test again for safety. And this leak was identified at one of those high pressure tests, and the job was shut down. Yes.
Yeah, the division has no further questions.
Okay, can we go back to the, was it 23?
Cost or
Oh,
the,
no, one more, there we go. Now, I'm seeing the trace of the lamb well there. There are no other wells on this unit? Or
this is at the time of spud to show what the well situation was. So this is the first well in that drilling unit. And Mr. Wall, maybe you could testify again that this was, there's no other wells on the nearby area and you have limited well control, is that correct?
That is correct, yes.
so the lamb well is the first well.
It is the first well in this drilling unit, yeah.
And now are there any more, or is it?
Are there any other wells in this drilling unit now?
Not in this DSU, no.
And then the idea of risk, okay? We've talked about this many times. And I recognize the geological, the lithology, the structure, and this presentation we're seeing here seems to reflect from one section to the next. Do you see any time where this would change due to knowledge through mechanical, like you learn on things, or is this risk kind of standard? I mean, are these always going to be there?
Yeah, I mean, I think through our operations, yes, we learn over time and we try and mitigate risk, but we can never essentially eliminate the risk. We're always, the formations are the formations. We can't change them. Dealing with clay, we do our best, but mistakes happen or the challenges still exist, and we can't get rid of that risk. We try and be more and more successful as we drill it more and more, but these things still happen to us.
Do you find the risk goes up? I mean, you used to do mile laterals, 2 miles. Now I know there are some 3 miles out there. Do you see that risk dramatically increasing with the length of the well, or is that not the case?
Yeah, I mean, I think anytime you have prolonged exposure without casing to the formations, you inherently take on more risk. So yeah, the longer the laterals, the higher the risk of certain things happening.
That's always an issue, ongoing questions. So thank you for addressing that.
Mhm.
Okay, I'd like to turn the time over to the division, or do you have anything else, Mr. McDonald?
No, that concludes our presentation, Mr. Rogers.
Okay, turn the time over to the division for their presentation.
Yeah, thank you. As was indicated, the division filed a response where we're not in opposition to this request. We reviewed the filings, we reviewed the declarations and listened to the testimony here today, and the division is in support of this request.
Thank you. Would you like to make that your closing statement or? Okay, thank you. Ms. McDonald, do you have a closing statement?
Yes, thank you, Mr. Rogers. For the record, I'd like to move for admission of exhibits 1 through 19, replacement exhibit 20, exhibits 21 through 24, and exhibit 25 as supplemented, as well as Mr. Burns and Mr. Wall's declarations.
Jason, do you have any objection to that? Objections. Okay. We got up for a bit.
Oh, they're omitted?
Yeah, oh, I'm sorry, I forgot that.
Okay, yeah,
we'll
and then
omit
just,
both.
I was just gonna, in a closing situation, the statement that, again, we believe the statutory and regulatory requirements have been satisfied, that the relief is fair, reasonable, and justified, and ask that the request be approved by the hearing examiner as submitted. And again, thank you for your time, Mr. Rogers, and to the DNR staff for their assistance in allowing the virtual appearances today.
Okay, thank you. We'll sit out a moment. Thank you. We were back on the record this time. Just a point of clarification. This is unique in such as there's no other wells in there. It's like a first well. And so what's the issue from, well, it's 2021 it was drilled to now? Why do you wait so long?
That I can't answer.
Yeah.
That would have to be the.
Oh, are they still there? They're there.
Mr. Burns, maybe you could answer that question?
Yeah, I mean, this is just, again, Newfield or Oventive at the time, we drilled the wells and opted to carry these people, but we should have gone to try and get these NOPs out at that time. And now we're just trying to go back and clean up all of these wells to give all of these owners an opportunity to participate or lease. And we just, at the time didn't have the capacity to do that. We do now, and we're trying to go back and make sure that everyone has an opportunity to lease or participate.
But you use the term carry these people, so that means they have benefited over this lack of Not
Yes, in other words, they have the opportunity to come in at 100% of what the cost was,
Mhm.
even though the well's been producing and they know what
Okay, so they have
how
a time frame.
successful it is, yes.
Okay. So it's just a timing, a workload, I guess.
Right, and as you know, by the amount of these that have been coming in front of the board and yourself, that they're trying to clean everything up as soon as they possibly can. We're trying to get them all done by the year's end.
And as you drill more wells in this section of assessment you are, will they be enforceable those individually?
Again, there is the regulations, the new regulations that were put in place a couple of years ago allow for a process that may expedite that without having to go in front of the board. If, for example, they challenge any of the, they want to challenge the non-consent penalty at that point, they can then ask for it and then come in front of the board proceeding. But there is a streamlined process under the new regulations for additional wells within a drilling unit that have already been compulsory pooled.
So if one of these parties that was force pulled today, or, well, or in this process, chooses to, participate in the next well, then that would have to come before the board?
No, if they
You just
participate, there wouldn't be a situation that would be governed by their election under the, joint operating agreement then.
Well, we're still learning that process.
Every time there's a well, they will send out notice.
Yeah.
Yeah, in other words, force pooling compulsory pools the drilling unit, but then there's a well by well election.
All right, thank you. Well, today, after reviewing the request for agency action, all exhibits having considered the evidence presented here today, I find that Ovintiv has provided sufficient notice of opportunity to the non-consenting CP owners, and those owners identified in the request for agency action did not timely elect to participate in the wells and therefore should be deemed non-consenting parties. I find that 300% non-consent penalty is fair and justified given the economic and geologic conditions present with these wells, and find that it would be appropriate to impose that requested non-consent penalty. I find that Ovintiv has met its burden of proof to show that they are entitled to force pulling of the named interests and other relief requested in the request for agency action. Mr. McDonald, will you prepare a proposed order?
Certainly.
Okay, I then will present it at the findings and conclusions at the board next week at their hearing. Any other comments before we close? There are no other issues. I thank you for your participation and will adjourn this proceeding at this time. Thank you.
Thank you.
Good
Morning, everyone, and welcome. My name is John Rogers. I'm Environmental Manager with the Division of Oil, Gas, and Mining, and I've been appointed by the Board of Oil, Gas, and Mining to act as a hearing examiner in this proceeding. Today is Wednesday, August 21st, 2024, and this is the time and place for the hearing examiner proceeding for docket number 2024-045, cause number 132-48, in a matter of the request for agency action of Oventive USA Incorporated for an order partially vacating the order entered in cause number 139-114 and instead pulling interest, including the compulsory pulling of the interest of certain non-consenting owners in the 9 Bruce wells identified herein in a drilling unit established for the production of gas, oil, and associated hydrocarbons from the Lower Green River Wasatch Formation, comprised of all of section 14 and 23, township 3 south, range 2 west, Went to Special Meridian, Duchesne County, Utah. We are holding this hearing with an anchor position in the Department of Natural Resources building in Salt Lake City, Utah. We also will be hearing testimonies and presentations in person and virtually, and the proceedings will be broadcast on the internet. I wish to thank the division staff, legal counsel, and petitioners, and the department technical staff for allowing these proceedings to go forth both remotely and in person. Before we begin, are there any members of the public or respondents present that wish to comment on these proceedings? Let the record show no public respondents are present. We'll take appearance of counsel this time. Oventive?
Yeah, thank you, Mr. Hearing Examiner. Mitch Mayo with Lear & Lear PLLC on behalf of petitioner Oventive USA Inc.
Division?
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
My counsel is Gary White of the Attorney General's Office. Some procedural items before we begin. I have received declarations from Mr. Ashley Ellison, a senior land negotiator for Oventive USA Incorporated, and Mr. Christopher Wall, a reservoir engineer advisor for Oventive USA Incorporated for this matter, and I reviewed them before this hearing. Both individuals have testified the board as expert witnesses before. Is that correct?
That's correct, as recently as July.
Okay. Does the division have any objections to these declarations, or are there these individuals being qualified as expert witnesses?
No objection.
Thank you. They are each recognized as experts in their particular field of study and work. Mr. Mayo, are the witnesses present today?
That's correct. With us today are Mr. Ellison and Mr. Wall.
Okay. Can we swear them in at this time?
Please raise your right hand. Do you solemnly swear that the testimony you shall give in this proceeding shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Yes.
Okay, we accept them as expert witnesses, and division, are you okay with that? Okay, thank you. We'll now proceed to Mr. Mayo for his presentation.
Thank you for that introduction. Jumping right into this, just to clarify, as was done in prior hearings, Mr. Ellison will be testifying as an expert in petroleum land management, and Mr. Wall in petroleum engineering. The board, and by designation, the hearing examiner, have jurisdiction over this matter pursuant to Utah Code 40-6-6.5 and the implementing regulations contained in R649-2, -8A and -9A. A copy of the request that we're discussing here today was sent by certified mail to the known parties sought to be compulsorily pooled and sent by regular mail to all other production interest owners within the drilling unit at their last known addresses as disclosed by the relevant realty records of the county recorder, as well as Oventive's internal records and subsequent searching. In addition, the request was mailed to all relevant state, federal, tribal agencies as necessitated by the mineral ownership in the unit. In addition, notice of the filing of the request and this hearing was also duly published in the Uinta Basin Standard on July 31st, the Deseret News on August 2nd, and the Salt Lake Tribune on August 4th, 2024. On August 12th, the division filed a notice, a response expressing no opposition to granting the request pending the confirmation of sufficient testimony here today. We believe that testimony will be presented and has been in the declarations. To clarify, no other objections or responses were filed to the request, and there are no respondents here today. To briefly summarize, this cause is fairly typical with what we see to west in Duchesne County. This drilling was established in 2015 in cause number 139-134, as subsequently modified in 2023 in cause 130-16 to reduce the heel toe setbacks. Oventive is the majority interest owner as shown in Exhibit 8 on file, Petitioner's Exhibit 8, and as discussed in Mr. Ellison's declaration on file. I mentioned a couple nuances. So pooling 1280 is fairly typical. There are two things that are slightly different. One is there's an existing pooling order that we're asking to be partially vacated based on this new pooling and the conversion that's taken place. And two is to essentially make one of the wells not subject to a non-consent penalty because of the election notification process. And so we'll get into that as we go. But before I begin, I should probably start with the existing wells. Pursuant to Order 139-90, which was entered in 2012, Oventive's predecessor drilled and began to produce from the Morrill well on Section 23 and the Mullins well on Section 14. Each of these wells had...
1 second here. Were those vertical wells?
Those were both vertical or directional wells. I'm not 100% positive.
One in each section?
That's right. Each of those wells had some unleased owners in them at the time, and each of those wells was pooled by order of this board in cause 139-114. That pooling order was effective February 20th of 2014. And the names of the parties pooled in those orders are on page 5 of the request for agency action, if anyone's interested in looking at those. Subsequent to that, in 2015, the board entered Order 139-134, which established this 1280 unit that we're here discussing today. In that 139-134 order, as is typical, the board ordered conversion to apply, meaning the day after, or excuse me, the first day of the month following the date of first production from the first long lateral horizontal well, all existing wells, and in this case, the Mullins and the Morrill well, convert to payable on a 1280 acre basis. Subsequent to entry of the 139-134 order, Oventive drilled the 9 Bruce wells that are issued here today in what I'll call 2 batches. The Bruce 1H was drilled, and that is the Bruce UT 2-14, 3-2, -14-23-1H well, was drilled in 2018-2019 with a date of first production of March 28th of 2019. Accordingly, the Morrill and Mullins wells, the existing wells, converted under the 139-134 order to a drilling unit basis, the 1280 allocation basis, as of April 1st, 2019. Subsequent, in light of this conversion, and the waiver of recoupment, it's appropriate for this board to, or for the board through this hearing examiner to vacate the existing pooling order, 139-114 order. And Oventive requests that be vacated as it pertains to sections 14 and 23 and the existing Morrill and Mullins wells only.
So are there other wells involved?
That's right. So in addition to drilling the Bruce 1H, Oventive subsequently, as of 2023, drilled 8 additional Bruce long lateral horizontal. So there are 9 wells that are here today before the hearing examiner. One of those wells, the Bruce 1H, won't be subject to a non-consent penalty, and we can discuss that as we go. The other 8 will be standard pooling order, non-consent penalty applied, 300% risk compensation award.
And what happens to the Mullins and Morris?
Well, the Mullins and Morrill have already been pooled, and those pooling orders have already been satisfied. By the terms of the 139-134 order, Oventive, in order to effect conversion, agreed to waive any outstanding recoupment.
So they have converted those wells already, and that pooling order is basically gone.
That's exactly right. It's officially gone after the board enters this order, but effectively it's gone, and it's just kind of a zombie order that's standing out.
So right now they're being paid as working as personas.
With respect to the Mullins and Morrill,
Yeah.
yes. And also with respect to the Bruce 1H, everyone was carried at 100%.
Explain to me why that happened.
Well,
Or is that for Ash?
I think I'll have Ash explain that or kind of talk through the Bruce 1H when we get there. There are 8 other wells, and they're all identified in the request. I'm happy to go through the full names for each of them, but I'll short cite them: the Bruce 3H, the Bruce 5H, the Bruce 7H, the Bruce 12H, Bruce 16H, Bruce 42H, Bruce 44H, and the Bruce 46H. Combined with the Bruce 1H, those are the 9 wells at issue here today. Now, I broke them up into 2 batches because there's relevant dates applicable to both. For the Bruce 1H, it establishes the conversion date. It's the first long lateral horizontal well, so the conversion of those existing wells happened relative to that Bruce 1H well. However, it was a couple years till the other wells were drilled. And since those wells, the other 8 Bruce wells, the relevant dates for those are the spud date for calculation of acreage weighted royalty. And those 8 wells, those 8 Bruce wells were all spud between June 1st and June 15th, 2023, and there were no new leases taken between that period, such that there is one acreage weighted royalty to apply to those 8 wells, as can be discussed as
Can
necessary.
I ask a question?
Please.
I'm very confused.
Oh, no. Okay. Then you should ask.
So the 2 batches have different conversion dates.
No. Conversion is a term of art that the board inserted into the orders to effectuate essentially how you allocate pay on an existing well. And if you think about it as a snapshot in time, the Morrill and Mullins well existed and were each payable on their own allocations, I think 640 acre allocations. When the Bruce 1H well is drilled and the first day of the month following the date of the Bruce 1H's first production, the Morrill and Mullins well, instead of being payable on 640, from that point on, they're each payable on a 1,280 acre basis. So that conversion only occurs once.
Well, I understand that. So I see where you're going there, but you got the 8, you got the 1H and then the 8 others.
Yeah.
You said they came in 2 batches. I thought you said there were 2 dates that are relevant to those. That's what I'm.
That's right. So the Bruce 1H, the date that's relevant to that one is the date of first production. And the reason that's relevant is because it establishes conversion. And so that's the date really that's most important with respect to the Bruce 1H. With respect to the other 8 wells, because Ovintiv is asking for the imposition of a risk compensation award, and because the hearing examiner will have to enter an acreage weighted royalty, the date that's relevant for acreage weighted royalties is the spud date.
So
So
1H.
for the 8 subject wells that we're asking
Each
for.
individual one.
That's right. But in this case, they all spud, those 8 Bruce wells all spud between June 1st and June 15th of 2023. So there's a 2-week period. Any leasing that happened during that 2-week period would change the acreage weighted royalty for one of them. But because there was no new leasing during that 2-week period, there's only one acreage weighted royalty to apply to those 8 wells.
And that simplifies it.
That simplifies it.
All right.
And feel free, there will be follow-up questions. I'm sure Ash will have a much better explanation than I will when we get there. So
No, I've read through this many times and
every time got a little
well,
confused.
it helped.
Well, I want to, yeah, thank you for raising that. So with respect to the 8 Bruce wells, the 9 Bruce wells that we're here to discuss, several owners of undivided interest in oil and gas in this unit and the subject wells have refused or failed to lease. They are identified on page 2 of the request. Alexis Rasmussen, Christine Taylor, Shauna Doolittle, aka Shauna Doolittle, and Vernon J. Morrill, aka V. John Morrill. There's one clarification to note, not a correction. These are the same parties, but Mr. Vernon John Morrill reached out several occasions and had some questions and concerns. We tried to explain it to him and to his counsel that there's a piece of his interest that is still unleased. I'm not entirely sure, to be totally candid, whether that point was made. Regardless, he has been sent a lease. His counsel has been copied on that lease. It's been explained to both of them, but there is still a piece of his interest that is unleased. If that lease is returned in the next week, we'll notify the board and make sure that whatever order is entered accurately reflects his election status.
When was your last communication with counsel for, did you say it was Morrill?
Gail McKechnie is counsel for Vernon J. Morrill. That's right.
Yeah, when was that?
Probably, I can double check, but probably a week and a half ago.
Okay,
The
so
lease
in the
offer
recent
was sent. Yeah, and it was probably 2 weeks ago that I spoke to them on the phone. So in the last couple of weeks. In addition to the named parties, there are several estates to be pooled. Those are identified on pages 2 and 3 of the request on file. Again, although Ovintiv believes it has leased and located all of the successors and voluntarily to pool their interest pursuant to the pooling clauses in the leases, there may be additional parties claiming buy-through under these estates due to incomplete distribution or lack of a probate order from the Utah court. Pursuant to the board's order on July 15th, in this cause, the notice of opportunity to participate required under Utah law was provided to them, to these estates by publication. Exhibit 22 on file is a true and correct copy of the affidavit of publication. No responses were received other than the following corrections of note. There were several parties in this instance who reached out and notified Ovintiv through counsel that either probates had been done in the recent past or that there was sufficient unrecorded information to tie up those estates such that they have been removed. There are 7 estates being removed from that list.
Yeah, I asked at this time, this seems odd to me that there are so many deceased parties here. Normally you don't see that many.
Yes and no. I mean, it depends. It really largely depends in my estimation, you know, not, this is just council's opinion. But it depends largely on how many owners there were earlier in time and units. A lot of these probate issues happen back or start back in the 50s, 60s, 70s. If back then there's 10 owners, there's usually fewer problematic probates when you get down the road. If in the 50s there's 150 owners, you usually end up with a larger kind of tree of probated issues that are. So it's not uncommon. I've seen more, I've seen less. But so there were 7 that were removed through that proof. Those are Alfred C. Keller, John H. Snow, Amy Folsom Snow, James Dalglish, Margaret Jean Walker, Margaret D. Walker, and Josephine Virginia Coons. Aside from these, what I'll call collectively removed estates, the remaining estates named in the REA and unidentified and discussed in Mr. Ellison's declaration remain to be pooled.
Sorry, what was the last one you said there?
The last name,
Josephine.
Josephine Virginia
Okay, yeah.
Coons.
Thank you.
Yep. As reflected on Exhibit 16 and discussed in Mr. Ellison's declaration, the average weighted fee landowner's royalty in the subject wells and is 17.17846413. And again, to clarify, that extra weighted royalty will only apply to the 8 Bruce wells that are not the Bruce 1H. For the Bruce 1H, the parties are entitled to, they've been carried. And Ash can explain what that means.
So let me just go back to some dates here now. The 1H was drilled when?
It began producing, its date of first production was March 28th of 2019.
And the rest, let's just lump them together. The 8 rest were June of what year?
June 1 through June 15 of 2023, just last year.
So that roughly 4-year period is what's causing this gap in there. So why the 1H is carried?
That's right. So the hearing examiner asked a question in a prior hearing about essentially why the delay in pooling. The short answer is staffing concerns. But in some situations, it really just doesn't make time or sense to go back and try and correct that rather than just tell the parties, we'll cover you on this well. And I think that's essentially the situation here that Ash can get into. Does that answer? Does that?
Yeah, well, I have some more, but maybe he'll explain those.
Notice was provided finally to all interested parties as required under Utah law and as reflected in the certificate of service on file. And the costs, including plugging costs, are just and reasonable and necessarily incurred. And in our opinion, justify the imposition of a 300% risk compensation award. With that clumsy introduction out of the way that probably created more questions than it answered, it's probably appropriate to start interviewing the witnesses. Ash, are you ready?
Yeah, let's do it, guys.
Okay. State your name and business address for the record, please.
Yes, sir. My name is Ashley Ellison. I'm a senior land negotiator for Oventive USA Inc.
Okay. And in that role, do you exercise responsibility over this drilling unit that we're discussing here?
Yes, sir. And I did not read my business address. I'm happy to do that. Forgive me. 4 Waterway Square Place, Suite 100, The Woodlands, Texas, USA, 77380.
Okay, thank you for that. Quickly, I'm going to have you confirm your declaration testimony, and then I'll probably ask you a couple questions based on the introduction and where things are going, and then have the division and hearing examiner follow up with you. With respect to your declaration, have you seen what's been filed as Exhibit 20, Declaration of Ashley Ellison?
Yes, sir, I have.
And did you execute or instruct your counsel to execute on your behalf that declaration?
Yes, sir.
Okay, and you're familiar with all the allegations contained therein, is that correct?
That is correct.
Okay, does the declaration constitute your full and accurate testimony here today?
It does, sir.
Okay, before I turn you over, essentially, can you give the hearing examiner a big picture? What's going on? Why the Bruce 1H is treated differently, and kind of what Oventive's decision was to do that?
Sure. Yes, this is a confusing matter. I completely understand that. Basically, in a perfect world, we just would have had the time and the capacity to force pool all of these immediately after the first 10K was drilled in each given unit. In a lot of these cases, even though 2 to 4 years have passed, we have not gone back and drilled infill wells in the units. But of course, in this case, the Bruce we have. And the simple reason for why we maybe didn't include the original 10K well into the forced pooling is simply because that well is paid out to 100%, and potentially some of these guys are receiving revenue, and at no point do we want to pay people and then put them in suspense for a non-consent penalty by any means. The reason why we a lot of times when you just drill one well and there's just a lot going on, in this instance we're force pooling 0.36% of the well. So the kind of, it's just depending on what's going on, it's not worth the effort at that moment to force pool that one well. Once you drill more laterals, in this case 8 more, that 0.36 starts adding up a lot when there's a lot of production associated with 8 more wells. So it does make financial sense at that point to force pool this unit. You're right, there is weird nuance with that original Bruce 1H well. And that's simply the reason why we didn't feel it necessary to include in the general compulsory pooling for those individuals. For the Bruce 1H, these individuals will have already simply backed in since that well is paid out. And the ones that just don't want to play ball or we haven't been able to locate, I'm sure we're simply netting their costs, and then that revenue goes into suspense until we can figure out where to send it, and probably escheats to the state after a certain amount of years. So just kind of the general framework of what we have to do with revenue if we can't figure out where it goes.
Okay, so let me ask a follow-up. You said something that I think is really important that needs a little bit of clarification. You said sometimes, oil's at $120 a barrel. Everyone in our team is going to be focused on drilling and production, and no one's going to be focused on cleaning things up. It doesn't make economic sense to focus on pooling at that time. To clarify though, how does Ovintiv ensure that just because it doesn't make sense for Ovintiv to pool, that the mineral owners who are unleased are protected? Can you kind of explain what you do, how you carry them, and how that essentially insulates them? They get kind of a cost-free interest in the well, essentially. If you can kind of walk through the.
Yeah, sure. Basically, and a lot of times I used to work North Dakota, and sometimes people simply go non-consent specifically because they either in North Dakota you back in at 150%. It's statutory if you're an unleased owner. In this case, they would simply back in at 100%, so you don't have to pay your proportionate share. And then once that well hits 100% payout, you get your full 8/8. Overall, if it's a very tiny interest and there's tons of wells being drilled, you just can't keep up with it at the time, which I'm sure this is what happened when the original Bruce 1H was drilled. So a lot of times it does not harm anybody to do that. Excuse me. And then even further, if you get well elections after the well has started drilling and producing, sometimes years in after, you can see how good that well is online. So again, it is a benefit to people if the oil and gas company does not have the capability to immediately force pool these parties. It is definitely not a detriment, I suppose.
Okay, thank you for that explanation.
Can
I think that's it, yeah, and now I'll turn it over.
So 1H has paid out at 100%.
Sure.
They're working interest owner now. They backed in, so.
That's right.
That's correct.
Why are you asking to force pull them? Why are you only asking to force pull 8 wells? You have 9 wells there.
Well, to be clear, and I just want to clarify this to this, Ovintiv is requesting that all 9, pooling is for a unit, not for a well. The elections are on a well by well basis. So Ovintiv is asking to pool the 1280 unit, comprising sections 14 and 23, and in particular the 9 wells. And all we're saying is for the Bruce 1H, there's no acreage weighted royalty applied. They just were carried at 100%. For the other 8 wells, here's the information you need to pool them as you would any other.
So the 9 wells is for information. There are 9 wells in this unit.
And you have to tell the story, right? It's confusing even with this. If we left out the existence of the Bruce 1H, it'd be hard to justify why the unit converted in April of 2021 or 2019.
Well, you're that, I just wanted to make sure.
Okay. Well, that's it. I guess one follow-up question, Ash, and I'll officially let you go. Based on your, expert opinion, do you believe the JOA proposed and the terms therein are just, reasonable, and fair to be imposed in this case?
Yes, sir. This is our standard JOA that we use throughout the basin.
Okay. With that, I don't have anything further except to ask you if you have anything you'd like to add or that you need to modify.
Sure, I will just kind of follow up with why there are so many probates, I guess, in this unit. In one of the exhibits, exhibit 4 in just kind of shows how cut up this unit is. There are 20 different tracks. And I just think that also contributes to the amount of chains, I suppose, tidal chains that go into these. Some of our units have 5 or 6 tracks. It simply kind of just depends on what's been going on in this general area throughout the last 120 years. Unfortunately, this one's simply cut up. And in a perfect world, everybody would probate their estates. Sadly, that is not the case. And we're just kind of dealing with it the best we can, I guess. That's all I have. Thank you, everyone.
With that, I'm done with him and Hearing Examiner Division
Okay, thank you, Mr. Ellison. We'll turn the time over to the divisions or questions if they have any.
Yeah, I have some questions just to help me clarify some stuff, Ms. Allison.
Yes, sir.
So, and anyone feel free to step in if I mess this up. So we had the two existing wells, the Mullins and the Marl, in this unit. They were pulled by order 139114, and that had a filing date of February 20th, 2014. I'm just looking back in the request for agency action. And on page 6, we list out the parties that were pulled under that order. There was 3 parties in section 14. There was 6 parties in section 23. Today's request is to pull 4 parties for this drilling unit. My question to you is, I look at their names and none of them are the same parties.
Mhm.
And I like the parties that were done back then and the parties today. Could you help me understand kind of where those parties went and where did Mr. Alex Rasmussen, Christina Taylor, Shauna Doolittle, and Vernon Morrow, where did they come from?
Sure. So the simple answer is I don't know definitively. Generally, I can answer that a lot of times over the course of when these wells were drilled and pooled. What year was that, Mitch? When
The Mullins and 2013 probably drilled and produced. They were pooled in 2014 and spaced in 2012. So split the difference, say 2013.
And so over the last 10 or 15 years, as more wells have been drilled in this area, more people are just aware of what's going on. So a lot of times people sell their mineral interest, or most likely Ovintiv or other non-op companies kind of key in on the people that are on this forced pooling list and target those people to lease. Because this is like a clear, hey, these individuals we can't find or don't want to play ball. So there are other companies that will focus on these parties and just try to get them leased. So there are 6 or 7 participating owners in the 10K wells, besides Ovintiv. And I would not be surprised if some of those parties leased these individuals and they're simply now participating owners in the 10K units, I guess. But to your question, you're right that in a perfect, you would think that the names on that we are forced pooling today would be the same names. Sometimes that occurs. And then sometimes over the last 10 or 15 years, there's just general title changes that occur, or they are just leased in that time frame.
Okay. My next question, we brought up Mr. Morrow. Maybe you could just help explain really quickly. So he is currently leased as to some interest, but you believe there is a 1 acre parcel, I think your declaration says, that is unleased. Could you just, for my benefit, explain why is that not covered under his previous lease?
Sure. The map here kind of helps explain the awfulness of this sometimes. Mr. Morrill owns mineral interest in 5 or 6 of these tracts. I don't know specifically which ones off the top of my head, but we have, sorry, go ahead, Mick.
But I think I might remember that it's tract 3D. I think it's this little sliver down here, if I remember right from his lease language.
Sure,
Sorry,
thank you. Oh, no, you're good. Better to have all the information than snippets of it. We have taken leases in the past from Mr. Morrill that we believed at the time leased the entirety of his minerals. A lot of times you'll lease and then you'll send all of those documents to a title attorney to review and to give a title opinion. We then get that title opinion back, and that helps us understand where we may have made mistakes. So in this case, we inadvertently left off tract 3D. I believe that this tract was deeded and reserved the minerals, but we save and accepted that 3D tract in his lease. And when there's a lot of tracts involved in multiple leases for individual tracts, a lot of times it's just hard to explain why we have signed a lease for these sections, but we're still saying that you're unleased for different tracts in that section. I've talked to Mr. Morrill. He's an older gentleman, very kind guy, but the nuance of these tracks is hard to contemplate if you're not dealing with it all the time, I think. We've had multiple discussions with his attorney and him, and would love for him simply to lease his 1 acre tract, and then would not have to include him on this forced pooling.
All right, thank you.
Yes, sir.
That leads me to my next question. I believe Exhibit 8 has a summary of working interest owners. And I think you mentioned earlier there's about 0.13% non-consenting pooling parties. Your declaration, let's see what page that was. I think on page
That is
5.
0.03. I don't know if that matters. If that's-
0.3.
0.13. Your declaration, paragraph 17, page 5, lists the 4 owners, lists their working interest amounts. Just my rudimentary skills, I believe that's more than 0.13. I just would like to get a clarification on how much working interest we are compulsory pooling.
So he's saying this doesn't.
Yeah.
Yeah, the 4 on my declaration totals to 0.18. So that is a good catch. I do not know off the top of my head. I think one of these dropped off, or I may have removed Mr. Morrill's thinking that we would have leased him by then. Let's see. Nope. Must be one of the other ones. So we can look into that and dial that in more. That is a good catch. Usually, and there's always kind of like a 2 or 3 week gap where there's just alterations that go into these as notices go out and we remove individual parties from these. Those numbers move around, and we just need to dial that in correctly. It will be either 0.13 or 0.18. Both numbers very small, but make sure that we figure that out correctly for you.
Just to get it clarified so that they're consistent.
Yes, 100%.
So with that, my next question involves Shauna Doolittle. So just one of our duties is just to look at and ensure that we feel like notice was properly given. Exhibit 11 for Shauna Doolittle, there is an address given on each letter, somewhere in Germany.
Yeah.
However, I did notice that the mailing address is a different address in California. And correct me if I'm looking at this wrong. Do you have an explanation, address-wise, the address we use for Shauna Doolittle?
I think we send these notifications out to as many addresses and sometimes get additional info of where potentially we should be sending these make every effort to figure out the best way for people to respond, I think. At the end of the day, there's the Germany address. Thank you. At the end of the day, I don't want to be here to force pool anybody, and I would love if we could get a hold of everybody in the DSU to lease. It's just simpler for everybody. I do not want Shauna Doolittle to back into these wells once they reach 300%. That just sounds awful for everybody. But in this case, it sounds like we tried to reach her potentially in Germany and then also in California. Oh, there's the California address. I think there's nuance of how. Yeah, go ahead.
I mean, that's not her mailing address. That's just the global processing address that it's sent to go out to Germany. So I don't think that's a different address.
Okay.
So that is the simple answer. I was expounding on the larger answer, I guess.
Which is also, as I understand, why there's the only reason she's being noticed by her location. They assume and have no reason to believe the mailing didn't get to that address in Germany, but there isn't a confirmation available through the mailing service. So the best we could do was that it was delivered to the global processing facility in California, and then assume that it was delivered from there. But in order to be sure, notice.
And she was noticed by publication.
That's right.
Okay, great. All right. One last question. Yes. We talked about the Bruce 1H, and you mentioned that at 100% payout, these parties then would receive their 8/8 interest. What happens until payout? Just from my understanding, are these parties receiving anything, or are we just looking at they have their expenses that would have been covered? Is that what's happening up until payout?
Yeah, basically they what they would have normally, if you participate in a well, you pay, let's say, $1 million, and then you would gain that $1 million until you pay, until you're even, basically. In this case, they do not pay $1 million. So we just put that interest in kind of in the red until they make up that their interest's full amount, and then they back in at their full interest. And then they start receiving jibs, but also start receiving the revenue. And when nobody pays their jibs, because like this individual, I'm sure we probably won't be able to find her for her to pay jibs. We simply net her jib payment with her revenue. And usually when these wells are good, that revenue will be much more than those jib payments, I guess. But sometimes later on in a well's life, that revenue does not make up for the jib payments, and then the oil and gas company is just on the hook for that difference, I guess.
And the additional revenue it just placed, and you may have already addressed this, and I missed it, is this you just placed in an interest-bearing account? What happens to these parties?
Yeah, it's simply if we don't know where to send it, it's just put in a suspense account, and we have just lots of individuals where we just don't know where to send. And I think Mitch would know more about the escheating process, but after certain years, that interest then goes to the state, where it kind of sits there, and I think the state can collect the interest on it. These individuals can go to the state and say, "Hey, I'm Mitch Mayo. I've been in suspense for forever." And as long as you can prove who you are, they will release it at that point. Same thing with Ovintiv. Before it goes to the state, we will release people from suspense all the time. A lot of times they're put in suspense for probate issues, and then they probate their estate. They're the definitive mineral owners, and then they get a very large check, that initial check, from all the money that's in suspense.
Thank you. And I think I may have said that was my last question, but that does bring up one more thing I want to ask.
That's
So,
fine.
were the uncommitted owners in the Bruce 1H the same people that are compulsory pulling from non-consenting parties? Do you know?
Yes, these individuals for the 8 wells would be the same individuals that we would have force pooled for the 1H well if we had had the time and effort to do it in 2019, 2020. And honestly, there may have been even more. We have been able to lease individuals as we put more time and effort just to find people. We're able to lease more individuals. So we slowly whittle away the people that are unleased. I think that's I'm rambling now, but that's kind of the answer to that.
All right, thank you. I appreciate taking the time to explain that to us. Thank you, Mr. Elson. No further questions.
Okay, thank you. Sorry to beat this to death, but I got a couple more questions.
Yeah.
Okay, on your request for agency act, you're asking the 9 Bruce wells. That's 8 and the 1H.
We're asking to pool the unit.
Yeah.
That
So that's why I'm wondering, where does the Mullins and Morrill fit in there? Are they going to be pooled?
Those wells have already been pooled in their own units, and pooling is
So they're not in this?
well, so pooling I think of as effectively everyone agreeing, you know, let's say it's 100 acres of farmland and each of us owns 5 acres. We want to get a tractor together, right? We all agree, let's collectively get a tractor because none of us need our own tractor, right? So we all agree, but in order to charge one of us for the costs of the tractor, it's not fair unless they've also agreed to buy this tractor and use it collectively. And that's effectively what oil and gas development is if you boil it down. And so pooling is essentially getting everyone who owns an interest in this unit to agree that we can develop it as a common resource.
Okay, I agree.
Once that agreement is in place, for time immemorial in Utah, they've all
Aren't
agreed.
there Morrill and Mullins wells in this unit?
Everyone in those agreed to common development in the 139-114, and everyone who's entitled to payment from those is noticed and given an opportunity to object to being pooled as part of this unit, right? If you think about the wells individually, it makes sense that you'd have to go back and pool each one of them into this unit. But the wells are they're just placeholders for accountants. The truth is what we're dealing with is mineral rights under the land. And whether it's in the Morrill or the Mullins or the Bruce 1H or the Bruce 5H, if I own an acre of minerals in this unit, I've been given notice, I've been set an election, and I'm now effectively pooled for common development.
Okay, and I see where you're coming, but when you list all the Mullen wells, not Mullen wells,
The Bruce wells.
Bruce wells, why are these 2 left off of there?
I guess the short answer is because the wells themselves, the Mullins and Morrill wells, don't need to be pooled. It's the mineral owners and the interest owners who own in those that need to be pooled, and they are pooled by virtue of this pool. So the wells' names don't really matter. Ash, am I thinking about it wrong? Does that make sense, what I'm saying, or am I off?
There's crazy nuance with this. I just assume that the Morrill and the other one,
Mullins.
the Mullins and the Morrill wells, I believe, isn't that with conversion they are established into the 10-acre, the 2-section DSU, and that's kind of.
The hearing examiner is asking a really straightforward and reasonable question based on what you and I keep saying, which is, well, yeah, but so why don't you just put them on the list of wells to be pooled? The truth is, they're not appropriate there, but the
I
parties under
understand,
there
so
are
you're
all
pulling the drilling unit. The rectangle. So, and in your request, you mentioned the 9 Bruce wells. So why is the 5/8 different than these? Why, I mean,
The reason
why do you
is
even list
because,
those wells there?
well, the only reason is because we have to make specific allegations about those wells that justify the board awarding non-consent penalties, risk compensation award, and assigning an acre weighted royalty. And so without talking about those specific wells, Ovintiv could come in and file a request to pool the Bruce unit and not mention any of the wells, but it would be really difficult to get the evidence in as to when the unit was established and when it converted and what the date of first production was. And so really the reason we mention those wells is so that we can put forth the evidence relevant to those wells that the board needs to enter the acreage weighted royalty and the non-consent penalty. Because those aren't going to apply to the Morrill and Mullins well, there's no reason to talk about those things anymore because all those interests are pooled in this unit and there's nothing specific being done to the Morrill or Mullins, meaning you're not going to decide that the 300% non-consent penalty applies to those. So none of the information relevant to those it would all be kind of extraneous and confusing, if that makes sense. I gather that it does not make sense, but it satisfies.
I guess what I'm saying, and maybe all of you think I'm all stupid here, but
No.
a well is a well, you know?
But we don't pool wells. We pool units.
I know, so
And we
that's why I
pool
think,
people.
why do you list the 9 wells there?
Well, and again, the reason is we're asking specifically for you to enter an order relative to these specific wells, not just pooling them, because every interest owner is being pooled. We're not pooling the wells, but with the Bruce 3H, we're asking you to impose a 300% non-consent penalty. The only way we can do that is if we list it and go through all of the predicate evidentiary showings.
So there will be no penalty at the Mullins. Yeah, prior well. All right.
That's right. No penalty, no accumulated royalty, none of that stuff. And that's really, if you want to boil down these whole hearings, that's what we're doing is putting forward just the evidence we need for you guys to say, you meet these requirements under the statutes and get it. The Mullins and Morrill wells won't be pooled, but all the interest owners under there are pooled. And nothing is being asked relative to the Mullins and
Well, this
Morrill.
whole concept of pooling wells is not correct. You're not pulling wells.
You know, my friend and mentor, Fred McDonald, has yelled at me multiple times kindly over the phone. You pool a unit, not a well. So yes, the truth is you do pool a drilling unit. You don't pool a well. And the reason being, you know, when you think about what it is, right? It's designed to get everyone within a spacing unit to agree to common development. You won't need to do that on a well by well basis. But in Utah, because of case law, there's a right to that well by well election. So that's where the pooling of a well kind of comes into mind. Also in Utah, for years, it was one well at a time.
Yeah.
And so pooling a unit was largely synonymous. Yeah.
Okay. All right. Move on to.
Mr. Wall, are you ready? Mr. Ellison, you can take a break and listen.
I'm ready.
Mr. Wall, will you please briefly state your name and business address for the record?
Yes, my name's Christopher Wall. Business address 4 Waterway Square Place Drive, The Woodlands, Texas 77380.
Okay, and your position with Ovintiv generally and how it relates to this unit?
Yes, I'm a reservoir engineering advisor for Ovintiv with jurisdiction over this DSU as well as others in the Uinta Basin.
Okay, and are you aware of, have you seen what's been filed as Exhibit 21, the declaration of Christopher Wall in this cause?
Yes,
Okay, are you familiar with all the allegations contained therein?
yes,
And did you execute or direct your counsel to execute that declaration on your behalf?
I did, yes.
Okay, you've heard all the discussion today, largely not about reservoir, but does the declaration still match your full and accurate testimony here today?
It does, yes.
Okay, is there anything you'd like to clarify or add before I ask you a couple of summary questions?
No, nothing to clarify.
Okay, in your expert opinion, Are the actual costs for the Bruce wells as reflected in Exhibit 17, were they fair, reasonable, and necessarily incurred?
Yes,
Okay, and are those costs within a reasonable variance of the AFE costs?
yes, they are.
In your expert opinion, were the Bruce wells economic, as that term is utilized in the 139, 134 order when they were drilled?
Yes,
Finally, in your expert opinion, the risks discussed in the exhibits and in your declaration, do you believe those risks justify the imposition of a risk compensation penalty of 300% relative to the Bruce 3H, 5H, 7H? All the Bruce wells except for the Bruce 1H?
yes.
Thank you for that. I now will turn you over to the division and hearing examiner for any questions or follow-up they have.
Vision. Yeah, thank you, Mr. Wall. Just, exhibit 19, was just out actual occurred risk, similar to what I've asked you today. I noticed that Bruce 12H lists one of the risks as slower than normal drilling, that it led to increased costs. Could you explain to me what that risk is?
Sure. So the Bruce 12H was one of the first, if not the first, actually was the second, excuse me. The second well that we drilled in a lower target in the Upper Wasatch. So when we drilled this target, we were taking some losses in our mud system and worried about hole collapse issues. So it did require a little additional time to make sure our mud system was correct. And what happened though was that it slowed down our drilling, so our rate of penetration was much slower than what it had been on previous wells in the Upper Wasatch Formation. And so longer time just means it's going to cost us more because we basically pay on a daily rate for the rig.
Sure. Okay, thank you. And then the Bruce 42H indicated that we lost 8,500 feet of lateral. So is that just a really short horizontal now?
Yeah, so after completing the well, the casing collapsed and we no longer have communication with the remainder of that wellbore, or roughly 1,500 feet is all that's really left
Okay.
that we're producing from.
All right, thank you. That's all the questions from the division.
Thank you, Andrew. I have no questions for Mr. Wall at this time. Turn the time back over to you.
Thank you. Not to, as you said, beat
Oh,
it.
wait, sorry, I didn't ask you for any presentation.
Yeah, if you'd like me just to summarize the division stance, the division, again, we reviewed this request, and as we've discussed during this hearing, there's a couple nuances here that are different than what we're used to seeing. However, based on our review and based on the exhibits in the declaration, the answers given to the questions here and the testimony given today, the division supports this request and feels like it falls within the regulatory guidelines.
Mr. Mayor, your closing statements?
Thank you for that. First of all, I do recognize there are some nuances here, and I want to just say something on the record to satisfy the board's minds and the division's minds, hearing examiner's minds. This hearing examiner process was set up, and the stipulations were largely nothing new, nothing unique, nothing novel. This has been done before in poolings. It is a little nuanced and a little confusing, but I hope to clarify, this wasn't an attempt to get around having the board here. This is something that has been done in the past. It's just feels new. So I just wanted to clarify that before we move on. And then in summation, again, we believe that the regulatory requirements have all been met. And based on the division support and the evidence and testimony here today, we'd ask that you approve the request as pleaded. And then that I'd submit.
Thank you. I'll take a few minutes to meet with Mr. White here. I'll be right back.
Thank you.
Off the record.
We've got an exhibit still.
Okay. Okay, yeah, so I was asking that, would you like to move to the exhibits?
Thank you. Yeah, I totally forgot, board secretary helped me remember. It's probably appropriate to move for admission of exhibits 1 through 23 inclusive. Those include exhibits 20 and 21 declarations considered here today.
Andrew?
And, notation.
Okay, so admitted.
Thank you.
Having reviewed the request for agency action, all exhibits, and having considered the evidence presented here today, I find Oventives have provided sufficient notice of opportunities to non-consenting CP owners that have those owners identified in the request for agency action did not timely elect to participate in wells and therefore should be deemed non-consenting parties. I find that the 300% non-consent penalty is fair and justified given the economic and geological conditions present with deep wells, and find that it would be appropriate to impose the requested non-consent penalty. I find that Oventive has met its burden of proof to show that they are entitled to forced pulling of the named interest and other relief requested in their request for agency action. Mr. Mayor, will you please prepare the order?
I will, absolutely. Thank you.
I will then present the findings and conclusions to the board next week at their hearing. Any other comments before we close? I appreciate your participation and we will adjourn this meeting at this time. Thank you.
Thank you.
Thank you to your online.
Thank you. Appreciate it.